Let's say it's her defense. So once again, I'll talk about only the document I have seen, but I'm not answering directly that she has a case.
She's in clear contempt of the process.
No, in law, we don't mention that this is in clear contempt. So just like the way we say a person is innocent until proven guilty. So it's only when it goes to court and then the court has gone into it and come to a decision, then that's when you'll be very assertive. So maybe you say it appears this is in contempt, or this may be. Yes, because once the person has not yet been found liable, we don't run ahead because the person has a right to innocence and to proving guilty.
Okay. Now she had doubts about whether or not the details of the petition given to her by the president is the same as was given to the committee hearing the petitions against her. Will this doubt have any foundation of merit, essentially? Can it be the case ever that the president would give her different details of petitions against her and the committee hearing the petitions would have different sets of petitions?
No, it's not likely. The president would not intentionally do so. No, it's not likely that will be done. Yeah.
I see. Counsel, I just want to piggyback off the issue of contempt, right? While we cannot state clearly as of now if she is indeed in contempt of the committee and the work that they are doing, what will her being in contempt of the committee mean for her and the entire process?
Let's further clarify. The committee is not a court of law, all right? So it's not in contempt of the committee. And let's be very clear. What you're saying is that it's rather a violation of the rules as mentioned in Article 146, Clause 8, and as clarified by the Supreme Court in the Justice Berry matter. So, yes, I think when I was answering to Mr. Okanse, I missed that. So, Mr. Okanse, actually, to the extent that the committee is not a court of law, we cannot say that it's in contempt of the committee. Yes, we can't say so. But
you know, we could say that she's in violation of the rules.
Yes, it's a violation of Article 146, this is Clause 8, and also as further explained and clarified by the Supreme Court in the Frank Ejechu case, and also in the what do you call it? In the Derry case, the Justice Paul Derry case. So what the Supreme Court said was that in the Justice Derry case, then they say yes, you may file.
Very well.
You may file that this is a violation, and then they also even mentioned that in that case the rules of court should also come out specifically. They should make more clearer rules.
I see.
Right? On the punishment, what would be done to such persons. Yes.
Who violates the regulations. But Counsel, how about you hang in there for me? Because I do want to talk about the issue she raised on Shining Stars. She said this group does not even exist, but the presidency accepted their petition. And I want to find out from you, I mean, the possibility of something as important as this falling through the cracks and what it means for the petition presented by the Shining Stars people, whether or not it could even be taken seriously at all, if indeed it is true that this group does not exist. But also more importantly, really, after she has done this, can and should the process continue? I'll come back to you with that. Let's head for the presidency now. If you've been watching us since the beginning of our coverage, you may have heard me say at some point that we'll go to the presidency where we expect in the Minister for Government Communication.
Even though Article 146 details how the processes of the removal of the Chief Justice has to follow, in her view, it is more enshrined in a certain agenda to get her off. We have someone on the line?
Absolutely. Alfred, let's bring in now lawyer Martin Kperbu, who's been paying close attention to happenings in the last hour or so. Lawyer, thank you so much for your time here this afternoon. But I'll pick your initial thoughts on this matter as well. Some of the issues she's raised, again, I'll reiterate that we know, but she went in depth in some others. What are your thoughts about what you heard from her today?
So, Kamini, I'm sorry to disappoint viewers and listeners. You see, the law currently, Article 146, Clause 8, says that the proceedings should be held in camera. And so that means that we don't see what's happening. And then there's been a Supreme Court decision that we should not discuss the merits of the petitions, etc., while the case is pending. They even said the petitioner can only disclose to the media that, well, I filed a petition against so and so and so, but the petitioner shouldn't go into the details. So, unfortunately, I have to obey those rules in order not to, fall foul of the law. So we can't go into the details. You see, what Justice Torkornoo is done, yes, a few weeks ago, I think, Kemini, fortunately, that week you moderated, or let's say you were the host of the key points that Saturday, where we have to discuss the matter of her waiver of her right to the in-camera hearing, where she said she wanted the proceedings to be broadcast. But when we finish, at the end of the day, it is clear that majority of lawyers and the majority of our society came to the conclusion that, look, 146 is clear. When they say in-camera hearing, and also based on the Frank Ejechun case and the Justice Derrick case, we should not go into the merits. The proceedings should not be broadcast live. So because of that, I cannot. I was supporting Chief Justice Torkornoo that, yes, we should. But mine was that we should first do a survey of Ghanaians. If we did a general poll and an overwhelming majority of Ghanaians said yes, then sometimes we could do so because the Constitution is made for us and not man for the Constitution.
I see.
Blah blah blah.
So lawyer, it is not true when the suspended Chief Justice tells us that secrecy of removal of justices has no place in the Constitution.
Sorry, say that again.
I'm saying that, so it is not true when she tells us that secrecy around the removal of justices is not in the Constitution or has no place in the Constitution.
Oh, is that how she put it? I didn't hear that side of it. But one thing is very clear. I joined, I don't know how many minutes I've lost, but the part I heard, that one didn't deal with that. But let's be very clear, Kemini. Article 146, Clause 8 says that the proceedings should be held in camera. And even apart from 146, okay, I'll read it, but we'll go to the Frank Ejechun case and then the, the Justice Derrick cases, which dealt with publication. The Justice Derrick cases, the announced one, where the announced documentary was broadcast and people saw it. The Supreme Court was very clear that should not be done. So let's go over 146 Clause 8. It says that all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard, blah, blah, blah. So the main thing, you heard the main thing, it says it shall be held in camera. And apart from that, as I mentioned earlier, there's a Frank Ejechun case where the Supreme Court held that, no, when a petition is made, the petitioner should only mention to the media that I have petitioned against so and so and so. Don't go into the content. So it's also true that though in this Chief Justice Torkornoo one, the contents were leaked. The petitions were leaked some weeks ago. We have read, but we cannot comment publicly. One thing is very clear, like I said, the chairman of the Constitution Review Commission, Professor H. Kesi Prempeh, is in favor of making certain parts of the proceedings public that citizens should know.
Right.
But that's for the future, not in our current Constitution. So for our current Constitution, it's a closed book. Secret or in-camera hearing is in-camera hearing. But what Justice Torkornoo is doing is advocacy, paving the way for future public broadcast for future further disclosure of such proceedings. That's how the law is built.
I see. So, in other words, she should have been allowing the process to just, take its course against her while we prepare for a better process with an amendment of the Constitution, because she raises concerns about that as well.
Second guessing a person who is going through such a trial is a very tricky one. So what is very clear is that currently we are not allowed to do what she did. But she's doing so, as I said, what she's experiencing, you and I don't know. So I'll be very slow to second guess her. But what is clear is that no, we can't go into the merits now. That one is very clear.
I see. I seem to be rushing you because in 5 minutes we should go to the presidency. We understand that the Minister for Government Communications will be responding to the Chief Justice's news conference in the last hour. But some of the things that she's mentioned, and lawyer, for the first time, we're hearing her respond directly to the public on some of the allegations, if not all of the allegations in those petitions against her. So let's take the one by Daniel Ofori on impressed, because she talks about, her traveling with a family member, interchanging that every now and then with spouse. She says that based on her appointment letter, she is allowed to travel with a spouse, with a family member. It's unclear which one it is because she used them interchangeably. I want to hear from you, from your knowledge of the system. Is that the case?
Well, so...
we can hear you. Can you hear us?
Yes.
Indeed.
Again?
Yes. I was asking really, what do you think she has achieved with this news conference?
Well, thank you. I must say that I'm disappointed, honestly, to say that the Chief Justice of the Republic of Ghana, he is the head of the arm of government that oversees matters of justice. If she herself is taking her own case to the court of public opinion, it means he has lost confidence in the system. Worrying concern for the whole nation. I think that very, very little as a way of projecting the image as Chief Justice of the Republic of Ghana. I think that she has been pushed to what she has done by frustration and built-in adverse remarks and loss of confidence and a personal vendetta on Justice Kwama, all have coalesced into what we have done this afternoon. I think the Judicial Council must be alive to its constitutional duty of counseling the Chief Justice on how she must behave publicly. We are paying the Council of State allowances so that they can advise the Chief Justice to behave herself. Now, if the Judicial Council is found wanting in this task, there's no justification whatsoever. The Chief Justice must not be allowed to fight her own cause in the court of public opinion. She has sworn an oath to do justice to all manner of people. And she keeps saying and reminding the whole nation that the law is the law.
Well, then, but is that not to say then? Is that not to say then, lawyer, that for her to come out?
A committee has been established by the president. She must allow the process to terminate. And then she can make her own pronouncement. on the final outcome. But now that she has taken the battle to the court of public opinion, what else does she expect the president to do? They to trigger off another challenge. I think, this hasn't done very well at all.
But I mean, based off what you have said, is that not to then say that perhaps she is trying to tell the people that she has tried to use the system to fight back and she hasn't won and she's turning to the people? That is why she's speaking to us today. She would have achieved that, wouldn't she?
So now, if an ordinary litigant tells the nation with the support of the Afro Barometer that the confidence of the citizens has waned totally, what would she say? So I don't think that the mere fact of the membership of Puama should drive her to what she has done this afternoon. If Puama is the object, it is a personal thing that she can sort it out later. Puama shouldn't be, her problem at all. Her problem, rather, would be to assist, to cooperate with the committee into bringing this whole thing to an end. You see, the way things are going, she's knowing herself in her own bone. And I would describe this as the musings of a drowning Chief Justice. She's only musing. And I don't think that, it is. I'm speaking now for and on behalf of my own friend Gertrude. I beg her not to not to repeat what she has done. I beg her. I'm only begging her. This one is not going to do her any good, any credit whatsoever.
I see.
She has now opened herself to attack by plunging her own dagger into her case.
Very well.
No, it's not
Very well.
acceptable.